welcome to our next conversation here at Parent Tween Connection. I am Clarissa Constantine. I'm the founder of the Parent Tween Connection, and I love bringing in professionals like Nick Roefaro to give you as parents more insight about the things that you may not even know that you don't know. So first of all, good morning, Nick. Thank you for joining me.
Good morning, Clarissa. Thanks for having me. Happy to be here.
Absolutely. So Nick is an estate planning attorney in Florida, and he is joining us today to talk about some of the essential lifeguards that every parent of a college-bound student needs to know. So, Nick, when you and I first met and we started talking about this whole, kids going off to college space, that's the world that I've lived in as a test prep coach for 26 years. We had a conversation about so many things that happen when a child becomes a legal adult at 18. And a lot of parents, like in my experience, I used to work in the office at the university where we handled the grades for students and transcripts. And the number of parents who would become irate when they were like, but I'm paying tuition, I should be able to see my kids' grades. And we had to say, well, but legally, not so much necessarily. There's a lot of things that change legally, which is why we had the idea to have this conversation. So where do we even start?
So I'm glad that you mentioned that, Clarissa, because the big thing is they're maybe 18 and parents are paying for their bills, they're paying for their tuition, they're paying for everything. But legally, those 18-year-olds are adults. So they have a whole different set of legal rights than they had the day before they turned 18. And so it's something I think parents don't think about because you think of a estate plan or you think of a will or a power of attorney or a health care surrogate, people automatically could go, well, those are for elderly people. And that's not necessarily the case. Honestly, everyone needs to have some sort of plan in place for the worst case scenario. But the big thing with college students is having a durable power of attorney and a designation of health care surrogate. Now, I'm only licensed to practice law in Florida, so this is Florida specific, but every other state has something similar, and I would encourage parents to go find a local attorney where they are. If they're not in Florida, to talk to them, have this conversation about what's necessary. Generally speaking, a durable power of attorney is a document where someone names another person to be their agent to help them with finances, bank accounts, investment accounts, paying their taxes, access to a safety deposit box, access to digital passwords, things like that, depending on what's in the specific power of attorney. And so when kids go off to college, a lot of times, they're not at home, they're somewhere else. They could be in a different state, but if not, they might be hours away. And it's beneficial to have the parent's name as a power of attorney now because the kids are adults. They have to agree to this. You can't just say, hey, name me as your agent. The kids have to do it, but it can be something where there's a discussion with your children about, hey, look, I think this is a really good idea because what if I have to get into your bank to get you some extra money? Or what if you're studying for exams or you're away on spring break around tax time and, you made a few dollars on your part-time job and you can't come home to sign your tax return or you need help with your tax return. Those are just a couple of examples of how the power of attorney can really become helpful. I know a lot of parents will have a joint account with their children to avoid the power of attorney, and that's okay, but I caution people, if you have a joint account, at least in Florida, with anyone that's not your spouse, that money is accessible to the other person's creditors. So while yes, it works, and yes, it's unlikely scenario, but in the event one of, the parent or the child got sued in a judgment against them, the creditor can come in and take the whole account. So I like the power of attorney better because you have the same access, but you don't run any of those same risks. And that would be for finances.
Well, and unfortunately, the fact is young adults do make sometimes some unwise decisions. And I think this is a case where we'd like to think, I just saw somebody posting on social the other day that somehow their kiddo ended up with a mom's phone or some such and racked up a $1,400 PayPal bill on some gaming platform or some such. And that was a kid that isn't even a legal adult yet. We'd like to think that there is some wisdom with age as they get to 18, but sometimes they do still make unwise decisions that could come back to haunt them in a civil suit or litigation like you're talking about. And, parents, I think, are wise to protect themselves. And we can talk a little bit about that more in part two about protecting your assets, right? For our Parent Tween Village community.
Right.
But the situations that you've mentioned are important, but they also don't necessarily even touch on some of the worst case scenarios, right? What are some, like, oh my gosh, this could be the worst case that a parent would want to have that kind of durable power of attorney to protect their kids in that
Yeah.
situation?
So the durable power of attorney is for finances. So, in that scenario is your son or daughter desperately you need to get in their bank account for some reason to get them some extra cash. That is really where the financial power of attorney comes into play. But also, I always recommend a designation of health care surrogate, and that becomes the more worst case scenario. Thoughts that parents don't want to have, and hopefully never ever have to deal with any of this stuff. But unfortunately, accidents happen and things happen to some kids when they're away at school. And if your child were to become incapacitated and couldn't make medical decisions for themselves, if you don't have a healthcare surrogate, you don't automatically get to step in and make those decisions if they're 18. It's a big, big misconception that, well, my spouse or my child can just jump in and do whatever needs to be done. In Florida, that's not the case. In Florida, there's actually a statute with a pecking order, and number one in that order is a court-appointed guardian. So, absent some extreme situation where it has to be the parent, and there's a huge prejudice if it's not, the court will appoint a third-party guardian. And most of them are fine; they're very good at their job because that's their job. But they don't know you or your child. You don't know them. So there's no personal relationship there. Also, it's an added cost. We don't want there to be a guardianship. You have to hire an attorney to file a guardianship. The guardian's going to get paid. And not to, scare parents, but our office dealt with a horror story like this several years ago, where a student went off to college and got hit by a bus at the bus stop, and was severely injured, handicapped. And they had obviously no healthcare surrogate or anything like that. It was an 18-year-old girl, like many parents, never crossed their mind. Well, she was in assisted living care for the remainder of her life from the accident. And every single year, her mom her mom did get appointed as the guardian, but every year she had to repetition the court to be reappointed because they're only 12-month periods of time. So not only is it the added cost every year to have to go through that and the hassle to go through the process, but every single year you're going back, bringing back up the memory, of that day that it happened. And, it just takes a toll on people. And so it's fairly inexpensive to have a durable power of attorney and a designation of healthcare surrogate. And, I know it's costly to send, students off to school, with room and board, tuition, and I don't even want to guess at how much it costs nowadays compared to when I went to school.
Sure. It's not inexpensive.
No, not at all. But, for a few $100s extra on top of all this, you at least have the peace of mind that in the event of an emergency, you're there. You're able to assist your child with medical decisions, on the healthcare surrogate. And then on the power of attorney, you can help them in an easy and safe way, safe from creditors, safe from, having to go through third parties, having to mail cash in the mail or something like that. Now I know a lot of college kids don't want their parents messing around in their bank account. But if you're paying for it,
there is some wiggle room
at a point as to why you should be able to have access to the bank.
Well, and that's where I think the distinction comes in of, like, okay, in the family dynamic, how do the kids want you engaged, or how do you choose to engage with your kids in their business? But then there's the family dynamic, and then there's the court dynamic, right? There's the legal, this is what the law says. So the power of attorney, you said, handles the financial things. Does that mean that, if your kid starts defaulting on a loan or like a credit card or something like that, like, do the creditors know, like, is that filed anywhere that those people know that you are that person, or is that only you can act on behalf when they're not able to?
Well, in Florida, you act on their behalf as soon as it's signed. And so in Florida, we call them durable power of attorneys. And what the word durable means is that it remains effective even if you become incapacitated. So um, you don't need to be incapacitated for your parent or whoever you name on these documents to do all these things. There used to be a way we did it. It was called springing power of attorney. And what that would mean is that it would only become valid if you were deemed incapacitated. The court outlawed those. My thought behind that is it created so much litigation that they just said, look, they're effective when they're signed, period. So these aren't recorded anywhere. By having it, you don't somehow become financially liable for that credit card debt or something like that.
Okay.
But what it does do is if your student is starting to default on credit cards, bringing up credit card debt, you can call the bank and you have the power of attorney and you can make the payment for them if it's something you want to do. And that's another big thing with kids when they go to college. I don't have the numbers in front of me, but I know a large percent of college students are will get into credit card debt in school. And I remember when I went to college, every day in front of the student union, they were giving out some new cool T-shirt or something if you sign up for this credit card, and
Yep.
everybody was signing credit card applications just to get the free shirt,
Absolutely.
not realizing that every time you apply, it's hitting your credit. So a large percentage of college students come out of college with low credit scores, partly because they don't have credit yet, but also because of things like that. So it's another way to help protect your child from starting life off, in the negative.
Right. So we've got the durable power of attorney. We've got the healthcare directive. Did I call it the right thing in Florida?
Designation of Health Care Surrogate, but yeah, it's the same. Yeah,
Okay.
same concept.
Again, like different terms in different states, but same function.
Yeah.
Those are the two primary. Are there any other aspects that parents just need to be aware of or do some research on about how in this realm that aren't necessarily as imperative or as like your kids screwed if you don't have this kind of situation?
Yeah.
What other things do parents need to have in their awareness?
Well, another document that we prepare for our clients, and this is a worst case scenario, is called a living will. And what that is that's a document that says you don't want to be kept alive in a machine. That's the only thing that's keeping you alive. My best way to explain that to clients is I compare it to a permission slip. You're not saying don't save me. You're not saying I don't want to be saved. What you're saying is, hey, if the doctors determine, and this is statutory on the legal side, and then the medical side, they have their own checklist that it has to hit. If a doctor determines you're in a persistent vegetative state, that you're authorizing the hospital to turn the machine off. Now, you're making that decision when you sign it. So you're not putting a burden on other folks that have to really decide, at least in Florida, the way they work. And so if you're going to do the healthcare surrogate and the power of attorney, you might as well have the living will for your kids. I mean, I know it's not something anybody ever wants to think about.
No, sure.
But, for most people, they don't want to just be there brain dead on a machine. And if you don't have the document in Florida, they can't turn the machine off. It's really to avoid, and it was a big news story in Florida probably about 20, 30 years ago, and I am pretty sure it was nationwide too, about Terry Schiavo, where she was brain dead on a machine, and there was this huge court battle between her husband and her parents about what to do. And that kind of prompted, at least around here, everybody to go out and get these documents. So it's not something people want to talk about or think about, but at the same time, it becomes a huge burden when someone is on one of those machines and it can't be turned off, because it creates, number one, there is a financial aspect. Even if you're covered by insurance, at some point they're going to say, hey, we're not covering this or we're not covering that. So there's a financial component. But in addition to, it's a huge strain on folks, because you feel this need. Well, I need to go visit. But the person's not awake. They don't know you're there. And so it becomes almost like a personal battle for people of how do you allocate time and what's right and what's wrong. And, everybody handles these situations different. But the vast majority of clients like this document, because most of us don't want to be kept like that. I have had some clients who say no for a variety of reasons. Some people say for religious reasons, hey, if I'm meant to be like that, that's how I'm meant to be.
Sure.
We've had people, and it's perfectly legal to say after a period of time you can turn it off, just in case some miracle happens and they come back to life, because that's not unheard of either. So
Absolutely.
I do recommend those documents if you're going to get the other ones, because we plan for the absolute worst. Um, but so if you're going to do them, you might as well add the living will. But
Mhm.
the designation of healthcare surrogate and power of attorney um, are very important. And the power of attorney too. Something bad doesn't even have to happen. That could just be something that helps
Mhm.
while your kid's away at college. They need some extra money for books, or um, you know, they need help. Somebody has to jump in and pay the cell phone bill.
Mhm.
You can access their account with the power of attorney.
Sure. So, is there anything, we're talking about this, presuming that understandably, right, the student is going off to college. They're not yet the full fledged adult
Mhm.
in parents' eyes yet. They're still the college kid, even in society's eyes, right? And so we're talking about this in terms of the paperwork that mom and dad need in order to be able to support the kid, like the child, the offspring.
Mhm.
At what point, well, first question is, at what point does that switch a little bit? Like, at what point do you think it's wise for parents to say, hey, wait a second, as part of my plan, I need to include my kiddo as my durable power of attorney or my healthcare surrogate, those kinds of things. And I know
Mhm.
that's kind of like you started out the conversation going, like, oftentimes we think about this in relation to the elderly, but
Yeah.
things happen. I mean, a good friend of
Yeah.
mine was gone in, a couple of hours notice before the age of 50. It happens all the time.
Mhm.
So, like, at what point do you see families starting to look at the other side of that coin?
So it's going to depend on the individual kids, and
Mhm.
the trust level. And, I don't want to say burden, because I think a lot of times parents feel like, well, I don't want to name my kids because I don't want to burden them with this. It's not necessarily a burden. Yes, it may lead to, them having to do a couple extra things.
Mhm.
But I think at the end of the day, they're happy to be named there. They're happy to help. You have to be 18 in Florida to be named as an agent in any of these documents. So certainly, I wouldn't recommend naming your children on any of these documents until they're 18. The power of attorney there's a lot of powers, and it's pretty broad. They have full access to your bank account if they have that power of attorney. So it really is going to depend on the trust level between the parents and the children, and how mature they are.
Mhm.
Oftentimes I see my clients add their kids, usually when they're around, almost out of college. Maybe not 18,
That early.
19, but maybe like, the second half of college. I'll start seeing people name their kids as their power of attorney and as their healthcare surrogate.
Mm.
The living will is an interesting one, and you don't have to have people named on them in Florida. My office does. We do put names on them. This way, it's just there's a conversation. The hospital talks to someone. There's not a phone call. Hey, we turned the machine off, without telling someone first they're going to do it. And one interesting thing I recommend to my clients is that, if you have more than one child who's an adult, name them to work together. And it's really not for a legal reason, it's to keep the peace. Because what can happen is, if you name your oldest child first and your next child as a backup, and the doctor calls the oldest child and says, hey, mom's in a persistent vegetative state, she has a living will, it says to talk to you, we're going to turn the machine off. And the oldest child says, okay, I understand. The youngest child's going to be like, well, wait a minute, nobody called me, this is all your fault, you killed our mom. And it's not the case, but sometimes, things happen that way. So
Mhm.
um, it's just keep the peace kind of recommendation that I make.
Yeah.
um, but yeah, I would say it all is going to depend on the kids
Sure.
themselves. But
Sure.
usually around the second part of college, people start adding their kids to these documents.
That's curious to me because that's actually way younger than I would have anticipated. I know in my family, it was definitely a case where my mother actually didn't want, she was very much like, I'm the mother, you're the kid, end of story, and didn't want me involved in anything until it came close to the end. And we actually had a pretty significant conversation about, like, my dad was the primary on it. And I was like, if anything happens to him, if I'm not secondary or if I'm not named, I can't help you. And then
Right.
it goes back into that guardianship situation, even for the elderly, that I imagine most families want to try to avoid if possible.
Hmm.
So,
Yeah, guardianships aren't fun, and they can drag on. And like I mentioned before, they have to be renewed all the time. And again, too, on top of each individual child's maturity level and parents' trust level with the kid. It's also family structure. Some people don't have anybody else to name.
Mhm. Mhm.
Some people who come from big families, they'll just name their siblings because they're still healthy, they're still alive. There's plenty to choose from.
Mhm.
Um, I do run into a lot of clients where they don't have anybody to name on any of these documents. So that plays a factor too. Now, one other thing I will say though is it's probably more for a discussion of protecting your assets for your family. But since
Mhm.
we're talking about the ages, if you are leaving things to your kids and we name them as beneficiaries, on that, sometimes parents will stretch the ages out much longer. I'd say
Mhm.
the average on that is the distributions will happen at age milestones, up to 40. Some people have them going to adult children until they're 65, and the reason for that is they become eligible for Medicare. It's
Mhm.
usually when it's a child who has some sort of handicap or disability,
Mm. Okay.
where the parents want to make sure that, hey, they're going to at least have insurance. So we'll stretch it out, and then insurance will kick in for them.
Right. Awesome. Any final thoughts for families tuning in, or have we covered all the bases of what they need to know as we
I
wrap
think
up?
we've covered it. I just think that this is such an important topic that not 95% of parents don't think about this when their kids are going to school, and
Mhm.
understandably so. And it's not something you want to think about.
Mhm.
It's one of those things, and I always tell my clients this when we sit down to do an estate plan. Hey, look, everyone's going to pass away someday, so you
Mhm.
have to have a will or a trust. In terms of these healthcare documents and the power of attorney, not everyone's going to need these. But
Mhm.
if you don't have them, and you can't wait, because then it's too late. Because once you're incapacitated, you can't sign them. So
Sure.
it always makes sense to just have them in advance, have them taken care of, put them away in a drawer somewhere, and hope you never see them again.
For
But
sure.
if you need it, they're there.
It's a better to have it than and not need it than need it and not have it kind of situation.
Yep.
So
Yep.
awesome. So Nick, folks can find you at roefarolaw.com, Roefaro
Yep.
law.com. Yes.
Yep,
And
that's the website. My email is easy too. It's just nick@roefarolaw.com. The phone number and all the other information's on the website. And if you're
perfect.
in Florida, I'm happy to help out if I can.
Awesome. So this portion of our conversation is going to be wrapping up here momentarily, and Nick and I are going to head into a conversation expressly for members of Parent Tween Village, where we're going to be talking about the legal side of protecting your assets for your kids. If you have assets, you have a home, you have retirement, you have investments and such, you've probably been working with a financial planner to make sure that your money is working in the way that you'd like it to. There's very much a legal side to that as well that becomes pertinent when the kiddos age up to 18 and beyond. So that's going to be our conversation expressly for members of Parent Tween Village. If you're not yet a member of Parent Tween Village, you can pop over to parenttweenconnection.com, become a member, and catch this in the archives. So Nick, thank you so much for your time. And we will see everybody on the next interview with our next professional. Thank you, Nick.
Right. Thank you.